We all know that a contract is an agreement enforceable by law. But what are creative contracts? Any idea? A very good evening to you, ladies and gentlemen. Law Essentials welcomes you to the fourth episode of the Lawyers as Peacemakers series. Our topic for today's discussion is contracts, comics, and creativity. Today we have an esteemed panel. The first being Dr. Camella Andersen is a professor of international commercial law at the University of Western Australia. She's a trade law expert for UNCITRAL and a member of the core group of the Proactive think tank. We also have with us Robert Rooy. He's a commercial lawyer and a developer of comic contracts, the world's fully illustrated contract. He's the founder of Creative Contracts. The purpose of the company is to afford vulnerable and literate people the dignity understanding the contracts they sign. He lives in Cape Town, where he tries to balance his work and family life with some cycling and surfing. We also have with us Mr. Anirudh. He's an experienced contractual, regulatory, and policy advisor to technology businesses. He has his chambers in Delhi. Thank you so much for being here with us today.
Thank you very much, Mohammed, and it's a pleasure to open the ball tonight. Good evening, good morning, good afternoon from across the world. I'm speaking to you from West Australia, and before we introduce ourselves with a bit more detail about what it is we do, I thought I would just share for a moment an interesting aspect, because what does it take to make a lawyer get exhibited in an art gallery? This is not something that lawyers set out to do when they study law, but it's something that has happened to myself and to Robert Rooy, who will be speaking in just a moment. We have managed to get our contracts exhibited in an art gallery because they are very strange. So at the Harry Gibbs Legal Heritage Centre, the Supreme Court Library of Queensland, they have a gallery, and the exhibit is called The Graphic Justice Pictures Worth 1,000 Words. And there's a comic book contract section there where you can see some of our contracts, the fully illustrated contracts, the Australian employment contract that we did with Oricon at the Comic Book Contract Project here at UWA in Western Australia. And you can see another world first, the Clement Gold fruit pickers contract that Robert developed for fruit pickers. We're also very happy to share some of our research and thoughts about how successful these contracts have been. And we will do that throughout this show. But I thought that interesting for you to start with the notion that lawyers can be exhibited in an art gallery. How different is that? So I think I would like to ask Robert to introduce himself, and then Anirudh, and then I'll talk a little bit about what we do at University of Western Australia with the Comic Book Contract Project, where we look at the impact of these contracts as well as their creation. So Robert, would you like to introduce yourself?
Thank you very much, Camilla. Yes, so my name is Robert Rooy. I'm an attorney practicing in Cape Town. I've practiced commercial law for about 25 years, and in the process realized that contracts are not very interesting to read. They are very difficult to understand, and certainly not suitable for people of low literacy skills. Which led me onto the path of trying to find out if there's a better way of doing contracts for people of low literacy, which led me to the idea of using comics, which was informed by people that did research in this area, and most notably people like Colette Brunswick and Helena Hopio and Tom Barton, who helped, who blazed the path in this area of the law. And yes, and so in 2016 we introduced the comic contract for farm workers at a farm, and since then we've rolled out these comic contracts to different organizations, in different industries and in different countries. I'm very happy to be here tonight, and for me it's this afternoon. I'm speaking to you from Cape Town in South Africa, and yeah, I look forward to your questions later, and I hope you are as inspired by the meaning that can be gained from really trying to use contracts as a way in which to establish good relationships with your contracting partners and create contracts that are user friendly, that people like, and that add value to to this field. Thank you.
Well, thank you, Camella and Robert. My name is Andersen Rostogi, and I'm the founder and managing partner of Ikigai Law. We are a law firm based out of India, and amongst the many things that we do, especially in the technology/innovation space, I think this topic is particularly very close to a lot of us at the firm, and which is to make contracts simpler and more accessible. And I think and obviously the value of doing that in the B2C context, as Robert just spoke about, especially with people with relatively lower literacy skills, for example, is definitely. I mean that's valuable. But we've also attempted to do this in the business-to-business context, and where we see that there's a fair bit of value of experimenting with contracts and making them simpler, even between two sophisticated business parties. So so we've done a fair number of experiments with contracts in both the B2C and the B2B context, in which I would love to talk about. But most recently, I gave a TEDx talk titled "Reimagining Contracts," and amongst the few things that I spoke about, the one kind of message that I give in that is that contracts should not only add value, but they should also be delightful to the end user. I think an end user should enjoy engaging with the contract, right? And I think why shouldn't we as lawyers take pride in what we put out, right? Something which people would have a smile kind of engaging with. So that's one of the key messages of the talk. And the other is, I leave the audience with a question, which is that a good contract would be what would delight a 13-year-old, right? So if your contract can be made in a way that a 13-year-old can engage with, and that should be true for any contract. I mean, however high stake the subject matter may be, I think that's doable, and I really commend the work that Camella and Robert have been doing, and that I think their contracts really are able to kind of satisfy that test very well. So that's what I would love to touch upon as I talk to you further this evening. Thank you for having me here.
Thank you very much, both. I think it's wonderful to share a panel with the two of you. We are obviously very like-minded. Robert and I have been like-minded in parallel for many years now, which is always a joy. So I am a professor at University of Western Australia, as said in the introduction. So I will choose to take a slightly more academic stance on this. I'm very privileged in that the work that I have been doing for the last nearly 5 years in this field can be run as research projects. So we get to do a lot of focus group testing, psychometric impact testing, and we have some data that really proves, I think beyond a shadow of a doubt, that this kind of contract, focusing on the relationship and the joy of the contract and the functioning aspects of the behavioral drivers that people need to understand in order to comply with their contractual obligations and avoid disputes, that all of these boxes are ticked with comic book contracts. And there's a simple way to try and explain that. So please bear with me as I become slightly academic and give you a PowerPoint slideshow that's taken from one of my lectures for my students, just a couple of slides, and hopefully it won't be too painful for anyone. So if we look at this particular slideshow here, my project over the last 4 years has focused on three very distinct aspects of what we call psychometric testing. One of the most important ones is engagement. Do people actually read their contracts? And one of the questions we are always asking people...
Is not visible?
I'm sorry? Is it not visible?
Well, yes.
You cannot see the slideshow I'm showing you?
No, only the browser is open.
That's very strange. So I don't know how to... Okay, sorry, I've never used this platform before, so that's not working. Okay, I'll try again. If I put share screen. Nope. Okay, I don't seem to be able to choose directly into the... Let's try this.
Camella, Camilla, just check maybe that you can use a different tab on your browser.
Can you see it
Yeah,
now?
well, now.
Yeah,
Okay,
there we
good.
got it.
Thank
yeah.
you. It was a different tab. I'm sorry out there on YouTube. So here is the slide that I was just hoping to show you. And this is about the engagement. So if you will recall, there are 3 aspects that we've been trying to test for the last couple of years: engagement, comprehension, and perception. And I'll explain what they are. And then have you think about some of the questions behind that, because I think the best way to get you to recognize this, the truth of these questions, is if you just draw on your own experience at home. So engaging with contracts. Does anyone actually read them? Well, do you? How many times do you click I agree without reading the terms and conditions? How many times do you, even though you're perfectly capable and you might even be a lawyer, not have time to read the contracts that get on top of your desk? I have had many conversations with import and export lawyers across the world who confess that they simply do not have the time to read the many contracts and orders and fine print that comes through their offices, even as lawyers. And when even the lawyers don't have time to read the contracts, then I think we have a bit of a problem with engagement. And there are a lot of really excellent articles that really prove this point. I mean, nothing proves this point more than the very fact that there are such a thing as herald clauses. You might have come across them. Tons of different clauses in different contracts that clearly aren't meant to be read because they're joke clauses, like giving away your firstborn. There's a classic. Now the herald clauses are so common now that there's a term in the Urban Dictionary. I think that's the ultimate nail in the coffin of contract engagement. So we clearly need something that engages better. So we've been looking at how comic book contracts makes people engage more in actually reading the contract and taking the time to understand what it's about. And it works. Like Annie Wood said, it's more fun, it's more human, it's more joyful, and people actually read them, so they engage with them. So that's a huge win. So we've seen massive statistical uptakes here. So the second one is about comprehension, and a lot of really great work has been done in this field long before I got into this game by people like Stefania Passera, who has been testing whether people understand things better when it comes alongside images. There's also a whole history of psychological evaluations on mnemonic techniques. If you trigger something with an image, the brain can remember it better. So it's very much proven that if people are given an image and simple language, and more about a relationship in relation to that contract rather than specific details that could be misunderstood, then comprehension is greatly valued. And we can hopefully have time to talk a little bit more about the relationship aspect of these comic book contracts, because that is something that they clearly straddle, that conscious contracting, as J. Kim Wright calls it, the relational contracting, which somebody was given a Nobel Prize for a few years ago. So very, very worth remembering that. The last thing that we look at, aside from engagement and comprehension in my project, is perception. How do people perceive contracts? And look, there's a reason why there are so many lawyer jokes in the world. This particular image here was drawn live at the 2017 Comic Book Contract Conference by one of our chief illustrators on the project. And it's very, very dear to my heart because it holds up these ugly lawyer masks in front of nice people when legal jargon just gets the better of you. And nobody really likes the contracting because it makes you partisan. It makes you not focus on collaboration or relationships, but more like drawing up a prenup before getting married. It's very negative, very punitive. And it can also be quite uninventive, like going around in circles, quite insular. And people don't like the classic traditional contracts because they often make them think more negatively about the relationship that they're about to embark on. When we started the comic book contract project 4.5 years ago with the Oricon project, we were, however, a little worried that people would be patronized by comics. Our contracts don't, the way that Robert's do, primarily lend themselves to people who have trouble reading, but typically lend themselves to people who really can't be bothered to look into the fine print and who don't particularly want to engage. So people who can read and can understand and who might not want to feel that they're being patronized in any way, shape, or form with images instead of words. So to make sure that we didn't get a negative response, we put a lot of questions into the perception of these contracts. And the data that we got back is really quite extraordinary, because while we were expecting a huge increase in comprehension when you compared comic book contracts to standard, we certainly got that. We were expecting an increase in engagement, comic book contracts over text, and we certainly got that. We weren't expecting the following, and that is that the perception statistic is actually the one that went up the most. the positivity that people associate with these contracts, not just with the contract themselves, but the people who are taking the time to make these contracts, to make the whole contracting process smoother. That positive perception is the biggest single statistical increase between comic book contracts and text-based contracts, which I think is incredibly interesting. It really does put the relationship back in the center of the contracting process, using images that can be quite emotive, quite interesting, and really focus on what's more important rather than the nitty-gritty of the fine print. I'm not saying as a lawyer that the fine print isn't important, but I'm saying that the relationship as a framework around those terms is equally important. And I think it's been very interesting to see how that particular aspect has been shining so hard. So just and I won't go through the entire presentation, I promise, but as a last image, the question that's out there, and the one that I really like, the way that Anirudh phrases that in his TED Talk, is, can law really afford not to change? Don't risk anything new. Let's go into a slow decline into obsolescence. A lovely cartoon there, which is very, very close to my heart. But honestly, the question is no, of course it can't. Legal tech is coming, and there's another lovely drawing by Louis Sylvester from the 2017 conference. But with legal tech coming, a lot of the automated tasks of the legal profession can be dealt with pushes of buttons, which means that as lawyers, our profession needs to change to become more human, much more human-centered, much more human-engaged. And one of the ways we can do that is to make contracts much more relational, much more human, much more joyful, much more engaging, so they can actually do the job that they're supposed to be doing. So that's quite a long introduction, and I'm sorry about that, but I am an academic, so it's hard to shut me up. But I think it's very important that everybody who's listening out there understands the basic framework of what it is that we're doing. So I hope that makes sense. So I'm wondering if now is a good time for us to show off some of the contracts we've done. So Robert, would you like to show off one of the creative contracts that you've been working on? You're muted.
Thank you, Camella. Okay, yeah, I think I'll quickly try and share an example of one of our contracts. I'm just going to see. Okay. Sorry, I must just quickly make sure that I get this right. Sorry, I think I'm also going to have to find my way around this technology here, because I'm not able to share my screen for some reason. I'm sorry about that.
Would you like me to show off some of the images I can get?
Yeah, if you don't mind. I seem to be unable to.
It'll just take me a minute to get that. So if you want to start talking about which one do you want me to do that?
Anyone that you've got there. I think what I would like to just mention is picking up of what Anirudh said earlier. You know, a lot of this was inspired by the question, what is a good contract? You know, it's a really important question to ask, because any product that's out there currently, any service, we all have an idea of what a good car looks like, what is a good you know, what does a good product in the shop look like? But when it comes to lawyers, and especially providing people with contracts, there's no uniform definition or agreed definition of what a good contract looks like.
But there shouldn't be. But do you think that there should be? I mean, isn't it a question of being bespoke and sort of engaging with the correct audience in the correct way?
Well, it depends very much on who you ask. You know, if you ask a lawyer what a good contract looks like, or if you ask a person who has to sign the contract what a good contract looks like, you'll find different answers. And I think it's that question which certainly inspired my interest in this area. And I think as lawyers, we are providing a service, And if we want to remain relevant, we certainly have to take into consideration the perspective of the users as to what a good contract looks like. How much effort are we willing to go to, as you mentioned, with regards to the criteria of perception? How much effort are we willing to go through to make contracts accessible to the people that are supposed to be reading and signing those?
Of course, and it's no coincidence that you talk about accessibility. You've got a big grant from the Innovation Law Institute in Hague for access to justice. I mean, these contracts aren't just fun and spunky and interesting and different and human. They're also representing a very significant access to justice for people who cannot access traditional contracts. So, would you like me to share the Clement Gold contract?
Yes, please. Yeah, please.
There you go. Can everyone see that?
Yeah. Okay. Okay, so maybe I can just speak to it. So there this is a normal employment contract where, as you can see on the first page, we introduce the parties to the contract. We try and follow the logic of the contract. So this is an employment contract, and we try to make sure that it's intuitive. So it starts off with an induction, and then it goes on to the probation, and then it's what the job is about. So we certainly try and look at how do we make a contract as intuitive as possible, and we try to follow the chronology of the relationship, because you want to make it easy for people to find the information that they are looking for. What is also one has to bear in mind with these contracts is that this is for fruit pickers. This is a contract for fruit pickers in the citrus industry. They know what a citrus tree looks like. They understand, so some of this information may be less obvious to someone who's completely unfamiliar with citrus picking, but this is designed for the users, and so they would know the difference. For example, the select picking which you see on the left, and the strip picking which you see on the right. Just as an example, because as I said, we really look at the contract from the user's point of view, and we test this with the user and see what is there, how would they understand this contract. Yeah. Yeah.
Do you want me to go to my favorite image? Here's my favorite image, this one here.
Yeah. Yeah, so there with absenteeism, so what I think what Camella is referring to is some of the anecdotal feedback that we received with these contracts, where in the past people weren't aware of their rights to, they weren't aware of their right to ask for leave in certain circumstances because they couldn't understand the contracts that they were signing. So what happened is that they would simply stay away if someone died or if the child was ill. And once they knew that they had the right, they would be able to, and what happened is, when they stayed away, they came back, they got a disciplinary hearing, and they were at risk of being fired. So now the poor employee has a sick child at home and is at risk of being fired. After signing this contract, they knew that they could apply for the leave. They apply for the leave. The employer is impressed because the employee is behaving responsibly, and the employer also then was in a position to be able to assist the employee with, the particular crisis of that employee. So it speaks to the idea of a contract being a foundation for a healthy relationship, a successful relationship, the kind of relationship that both parties want when they sign a contract. Parties don't sign contracts with a view to end up in court. That's not their aim. They want to have a good relationship, and the document and the contract should underpin that healthy and happy relationship.
Absolutely.
Yeah. Okay. Thank you very much. That's great. Thanks, Camella.
Thank you so much, Rob. So there's a couple of things that just spring to mind just looking at it. Obviously, our contracts are both similar and quite different, but there are a number of processes that we have in common. I mean, you do very thorough, I hesitate to call it anything else, but risk assessment to try and look at where are the real problems, what are the real issues in that specific relationship that we're now making a comic book contract for. Where do they actually hurt the most? What's more likely to be a problem? Where can we economize and cut away some of the things that are unlikely to be relevant? And where do we maybe need to actually add things? because I think we've both worked on contracts where we've not only taken things away, but we've added things that have been problematic in the relationship, but that the lawyers never thought was within their remit to clarify, which is a really interesting thing. So there's a couple of contracts that I'd love to share with you. So if we go to the comic book contract website, I'll see if I can share my screen again. An excess of screen sharing there. So on the comic book contract website, there are a number of different examples. And the first one that we worked with on my team was the Oricon contract, which won a prize, a Golden Quill for business communication, which was a lovely surprise. The Oricon contract is much more wordy than the contract you just saw Rob share, because it's not made for people who can't read. It's made for people who want a simpler, more human and perhaps more innovative basis for the very important relationship that is their employment. So this is a classic problem we always face, is designing the avatars, and we could talk, I think both Robert and I could talk about that for a few days, but we'll leave that one for later. But the difficulty of trying to find the right image is a very interesting one. And the thing about the Oricon contract is it's now been rolled out across 6 different jurisdictions. And so trying to get the images right for all different jurisdictions is nearly impossible. But what you'll see in this contract is you'll see the values of the company and of the employee being put right up front. So first you've got the company and their key attributes. I keep jumping backwards, forwards, but I think it's important to remind everyone that it's both. And the Oricon attribute that I was very much given on my team, of course, was to be playful with serious intent, to create a playful contract that still does the serious job of creating that. But it's the values of trying to find the values of the employee, also very important. You have to take an actual quiz to complete your employment with Oricon. You have to take a quiz to find out how many of these descriptors are right for you, and they actually use them in the company when they put together teams. And then there'll be a little mug or a t-shirt waiting for you on your first day. So I'll zip through this very quickly, but I just want to give you an impression that this also makes use of Annie Rood's technological sort of platform, that there's a lot here that is incorporated straight into. So these little green buttons will take you to policies that are housed somewhere else. This is very interactive, and you have to click that you've agreed them. So all of the onboarding and all the training is actually part of the initial contract process, which is really interesting. And just to show you something that is a bit added, like I spoke about before. So Robert will have added things that turn out to be real problems for the contracts scenarios that we're working on. Here is one that we added. So we took a lot out of the Oricon employment contracts, including a lot of clauses that once they saw them illustrated, the sponsor went, oh, that's not actually very nice, and we don't want to have that in there anymore. But one thing that they did put in was the importance of filling in timesheets, something that I think every lawyer can accept, the significance of filling in timesheets for your employer. But engineers have the same problem, that if they don't fill in the timesheets when they're on site, then the company can't bill them. But of course, new engineers, just like new lawyers, don't really comprehend the significance of this. But by putting this little image inside the contract, that problem has more or less gone away inside a huge corporation, which is very, very interesting. So that's one that I wanted to share with you. Another one that I wanted to share is a brand new one. See if I can find it. Nope, we've already done that. And that's the casual support worker for waste. Now, this is a project that we've just finished. We were supposed to do it in 6 months. It took 2.5 years because we had such problems with the avatars. This particular contract is also an employment contract. But it's a very different employment contract in that it is an employment contract for disabled people who wish to hire support workers in their own home because they want to stay in their own house, which is what WASTE is, an organization that tries to promote that people can do. And we had a lot of trouble trying to get the imagery right because this had to be a contract that spoke to people with a lot of different types of disabilities, some of them ocular, some of them mental, some of them physical. So a lot of different types of educational levels as well, both for the employer and the employee. So we've kept it very simple. And just like the ones that you saw with Robert, you've got those basic expectations, but you'll note that we're not scaling back on the words. Because we also had to have a version where the words are spoken out and the images are described for those who are sight impaired. So we need to have an audio version of this contract as well. So one of the things we did was we tried to make people think more carefully about, well, what is the task that you're actually doing? So that's the addition that we have in this contract. Then we have some issues with trying to define a domestic worker, some superannuation, how do we settle that? What about termination? And then, as we have in most contracts, there are some issues where you have some aspects that aren't necessarily nice. And we want to have nice contracts, as Robert said, but there also has to be some aspects where you maintain a certain right as an employer. And here we made the little manhole cover missing. So serious misconduct is one of those areas where very bad or risky behavior could happen. Stop, don't do that. Don't fall into that the dark black hole of serious misconduct, but it's still there and it's mentioned because it has to be. Just try to find a nice way to not make it so nasty. And then high five, and we hope it's a good relationship. And one of the things that we did for this one was we took the organization and we gave them sort of their own little icon. And as you might have noticed, we have them make little comments throughout the whole contract, which is set up as a conversation between the employer and the employee. So this contract is brand new. Waste has been rolling it out for about 2.5 months now, and it's raised a lot of attention here in Western Australia. And there are rumors that the Disability Commission are now looking at creating a standard template contract, and they want to use it, a visual template like the one we've provided, which is super duper exciting. Those are some of the contracts that I want to share with you. There's more on the Comic Book Contract website if you're interested. So I'll just mute now and I'll hand over to Annie Rood.
Well, thank you. And I think I don't need to really try and put in any more effort to make a case for these beautifully done up comic book contracts. I think what I would rather than talk about is there a good reason for us to go down this path, right? I mean, is it one that, of course, we all agree with the general principle that we would love to see contracts that are more engaging, easier to read. I mean, nobody can deny that fact. But are we in business? Is the business community really ready to then invest in these kind of contracts for your joy? Is there real tangible benefit for people to actually invest in this or not? And I want to answer that question with a couple of examples. And I would first take one of my favorite examples of General Electric, and I take that example because all of you know about that organization. And then I'll talk about a couple of examples that I have faced personally and or professionally. So General Electric actually at some point used to, and there's a very well documented case study, by the way, used to have this set of contracts for a particular aviation service that they used to provide. It was a certain set of devices sold in the aviation industry, and this was a set of 7 contracts of running into more than 250 pages that had to be negotiated between parties before GE could actually provide the service, right? As one would expect, these negotiations would run into months at times, with a set of lawyers on both ends, and then the business teams being pulled into, and a massive, colossal waste of time and effort, right? And so this new general counsel for GE Aviation at the time, took this challenge upon himself and said that, well, I'm going to super simplify this contract. But of course, I mean, you've got to make sure that while it's simple, it is also a sophisticated service that we're providing. So it has to have, all the bells and whistles that are necessary. And so he took this upon as a challenge, set up a team to look into this contract. And when they came up with what was a significantly simplified contract, they hired an external counsel, a law firm, to poke holes into that contract, right? Because you've got to make sure that this works. And after a fair bit of back and forth, what they came up with was literally a single contract. So 7 contracts into a single document of 7 pages, right? So down from 250 pages to 7 pages, single contract. And I just want to leave that as an example with you, that very often, and very often when we work in our own teams for contracts trying to simplify, I get a lot of pushback, like how is it even possible to really cut down text that we've been using for so long, and these are all kind of essential clauses. But if you really get down to the task, I think we have, as lawyers, become so used to some of the kind of jargon that we introduce, sometimes without thinking, and sometimes because we don't want to take a risk with kind of the language that has kind of continued for over decades, or maybe much longer in many cases. I mean, actually, some of the legal language that we use has carried on for centuries, right? So I think the moment we try and start applying ourselves, forcing ourselves to really question why is it that we need a certain text or a certain format even, you will see that there's a lot of clutter that can be done away with. The second thing that I think is absolutely essential is to keep the end user in mind, right? Who is this contract meant to be? It's definitely not meant to be for the lawyers of your counterparty. It is meant for the counterparty, right? So the moment you start thinking about who that counterparty is, you will design contracts in a very different way. And some of the examples that Robert gave about, contracts for farmers who had, say, relatively lower literacy levels, and so you would want to do it in a different way. We've actually also done contracts for the agro sector, where actually the farmers that we were dealing with could not even read and write. So even an illustrated contract may have not done the trick, right? And so what we did was came up with an audio contract where you literally super simplified the language and then read it out, because you can't, I mean, there's no point in reading out on record a 25-page contract. That's not going to serve the purpose, right? So you super simplify it, and then we read out the contract on record, and and you would pause every now and then and ask the farmer if the counterparty, if they understand what's being said and they agree to it, right? And this was done in the local language as well. So you got to keep the end user in mind and design your contracts for that. Another business case that I would again want to talk about is where we were dealing with a very interesting rooftop solar power company, and the challenge they were facing was somewhat unique. It was not that their customers could not understand. They were dealing with sophisticated customers because the product they were selling again was a high value product, right? But the challenge was it was such a new business model that your typical retail customer was just, I mean, one, they had to be convinced of the need for this new business, a new kind of device that was being sold. But they also, when you would send them a 100-page contract, and literally it was that long, they would kind of they would be very guarded about it. They would be not sure what they're signing up to, and nobody wants to read the 100 pages, so they won't know what's in there. And there's that trust deficit, right? Which because of which it was becoming very difficult to close the sales cycle, right? So the client actually came to us from another law firm that had drafted the contract to us to say that, well, hey, can you help us simplify this contract? And we said that, well, no matter what we do, I mean, one, there is actually so much jargon, and there's jargon for good reason, because there's a lot of jurisprudence around these kind of power purchase contracts. There's a lot of court decision, etc., around this kind of jargon. So if I were to start taking this away, it is not necessarily going to work in the client's favor. So what we did was we came up with a summary contract, not even a contract actually, just a summary of the contract, which was all infographics, right? But the idea was that if I can use these kind of graphics to actually convey the key points very simply to the purchaser, then they automatically lower their guard, and then they are a lot more open to this whole idea to begin with. So let me try and actually show what we got there. It was nothing as cool and fancy as what you've seen, Robert and Camella present. But honestly, we didn't really need that either. So let me just pull it up. 1 second. Can you see what I've got here? Okay.
Yes, thank you.
so actually by mistake I pulled up the wrong document, but it also has the same one of the diagrams that I wanted to show you. But this is how we literally started it, right? And the point being that you get to the core message, which is what does the customer really care about? First thing, what is it that I'm going to pay, right? And somehow if you hide the core message in all that text which runs into 100 pages, it doesn't work for them. So if you pull it out right front and center, right, you will see that you somehow bridge the trust deficit. You help the customer lower their guard, and really, once you build trust, you do better business, right? So that's the core point that I want to drive. And one of the unintended consequences of this was that not only, the sales cycles actually pleasantly so reduced because customers were a lot more open to this. But the unexpected outcome was that even our sales personnel started saying that, well, we are more comfortable with this. We understand finally what this document really says, and we are able to sell better. So that was, so what I'm trying to say is, in business, trust is all important, and once you build that, you will do more business. And somehow your contracts, don't treat your contracts as an unnecessary kind of, a burden. It is actually as important, can be as important for even marketing and sales, and therefore it's an important part of your overall docket, right? So that's one contract. In another case, we tried to actually come up with a flow chart, right? That you have this entire claim evaluation cycle for an insurance, that when do you, what do I do for the claim to be actually paid to me? And we said, well, if the business community is increasingly more and more comfortable with different formats, you don't necessarily do a 30-page pitch. You do a PowerPoint presentation, you use an Excel sheet, you use a flow chart. Why can't I use that for my legal documentation also, right? So that's one example of what we played with. And this is a comic book agreement that we've done again for farmers where, if you see that there is a timestamp actually, right, to show the chronology of events. And, so that's something that we were playing with. So yeah, so these are some of the examples I had. Let me get you back to my screen. Yeah. So it doesn't only have to be comic books. I think the whole idea, when I say that you have to develop something for the end users, obviously every end user is different, and you have to design for that unique end user, right? And there are a lot of and one last example of when I say there's a real business use case here is that when I gave this TEDx talk that I spoke about and I ended, I was very, I was quite happy that a lot of people approached after that talk. People really related to this whole thing. More than the lawyers, it was the average person who reached out, and which is to say, like, all this while we've been talking to the wrong audience. You don't have to convince the lawyers for this. They will never get convinced. The end user is already convinced that this is a good idea. But one of the people, sorry, Camella, you want to say something?
Yeah, I want to report something very positive. I mean, a lot of what you're saying is making me want to say stuff because I so agree with it. But we've actually seen a massive shift in the legal profession locally here, where it started being very difficult. Every time we had a new sponsor, we had to spend a lot of time trying to convince the council to not be scared. That's actually shifted a lot over the last few years. And about less than a year ago, my husband and I were asked, he runs a commercial business offering comic book contracts. And we were asked to go and talk to the WA Bar Association about the interpretation of these contracts because they're willing to get into it now. They've seen enough of them and they're becoming more familiar and less afraid. And it's very, very encouraging. So the law profession here is certainly beginning to give a little, which is nice.
That's good to hear. But so again, one of the people who approached me after that talk was actually a fairly senior person, director level person from one of the larger Indian government-owned companies. And these companies are typically fairly traditional in the way they do things. It's a government-owned company. There's a bureaucracy. There's a so I would expect somebody from that kind of a organization to be the last in queue, right, to approach me. But he came there and he approached me with a couple of his other colleagues actually, and he said he really would love to experiment with something like this for a contract that they do at their end, right? And so that was interesting. But I was quite surprised, and I asked him why so, right? Because you are an organization of a certain scale that anybody would want to do this contract with you in any case. These are prized kind of franchisees that you dole out, and it's not easy to get them. So you would be able to dictate any kind of terms in any way, in any case, right? So why do you care to make that contract actually simpler and whatnot? And I know that I was, actually saying something which is contrary to my own interesting position, but I really was curious to understand why would this organization really care enough. And what he said was, you're bang on. If I give a contract, people will sign it, right? But the point is that when I actually try to enforce the contract and I terminate it, I'm able to do that as well. But at that point in time, my franchisee is really disturbed because for the first time, they actually get down to read the contract, right? And I don't want that. That's not the making of a good business relationship, right? So I thought that was beautiful, and the fact that this gentleman from this organization, which I have typically considered, maybe wrongly so, to be traditional, to be of a certain kind, if he could be convinced and he could give me a perspective which I had not seen, I think we are, there's a real use case for business, right? So I think that I'll stop there. I don't want to share any more examples. I think Robert and Camilla have given some beautiful examples here. But I think I just wanted to leave you with this with kind of my experience with the business community here.
Thank you, Anirudh. You said something that I was really hoping we could explore a bit more, and I know you have a lot to say about this as well, Robert. But Anirudh talked about the trust deficit. I thought that was a really nice way of putting one of the problems. That image with the masks, the ugly masks in front of the nice lawyers. That trust deficit is something that I think comic book contracts go quite a long way to try and bridge, not necessarily because they're visual, but because they put such a focus on the relationship, and they make sure that nothing is hidden. One of my recent sponsors is a large financial institution, and the very first experience we had in our team, we read through this very long terms and conditions financing contract with lots of minute details, and we were thinking, oh, it's going to be fun to simplify that. But then we get to the end after about 18 pages of fine print, and then there's a clause that says any of this can change at any point in time. At which point the lawyer inside me goes, then what's the point? If these terms mean nothing because you can unilaterally change them at any time, if the moment I get to that bit at the end on the fine print, I'm going to go, what? That doesn't seem right. So we actually managed to convince them to put that right up in the front. So now, right up at the front, it says, with all the other comic stuff, it says that these are the terms and conditions in visual form. Note that sometimes things change, and when they change, we'll have to change too. We're not trying to trick you, and we'll be reasonable about it, but we might have to do it. But as long as we don't do it, this is what you can expect. So taking that trust deficit bomb that was at the end of this contract and moving it right up front to make it transparent, there's no surprises. And I think that's one of the most important things in a good relationship. Like you said, you don't want your franchisees to get surprises when they want to get out. You want to take the surprises out and make it all about a functional relationship and identify the behavioral drivers that need to be clarified for contractual compliance to take place, rather than those nasty surprises that mean that there are damages and punishment. So I really like the idea of this trust deficit. It's a good term. I'm not familiar with it, but I like it. And I'm sure Robert has a lot to say about it too.
Yeah, I think it's an important thing about creating contracts that people can easily understand, is because it has to be transparent, and especially using visual elements makes those clauses much more transparent. It's not that easy to hide it, and to hide difficult clauses in the process. The other thing I just want to pick up on what Anirudh said earlier was it's about or let me put it this way. What is important to understand, I think, is that when we create these contracts, we're not saying that visual contracts are necessarily bulletproof and cannot be, someone can't poke holes in them, like the example of General Electric. But what certainly from our point of view, what we are saying is it just has to be better than what we currently have. we often get people challenging the idea of using visuals in contracts, saying, yes, but it's subjective and it's subject to different interpretations, etc. Yes, it is, but so is normal text agreements. But it's much more important that someone is able to understand an agreement than signing an agreement that they don't understand. So it's also about just managing that expectation. And for the people in our audience, hopefully that will encourage you to try and experiment with these type of things, because you don't have to feel that you need to come up with something that is absolutely bulletproof. You simply, the bar is quite low, quite frankly, when it comes to quality of contracts. Every lawyer, normally surrounds their chambers with law reports that are filled wall to wall with cases about interpretation of text agreements. So, it's certainly not, it is not a measure by which we need to feel afraid of experimenting with using visuals and contracts like that. And then the last point I just wanted to pick up on what you said, Anirudh, is where you said that the salespeople actually understood what they were selling much better. That completely corresponds with our experience, where we did a contract for an insurance company, where they were asking us to do an explainer for one of their funeral insurance policies, and that they subsequently, we got instructions as to what their conditions were, and then once we illustrated them, it caused a need for them to have an internal meeting to try and find agreement on what exactly they meant. Because once we illustrated it, they realized that they actually each had their independent idea of what this clause meant, and that they didn't line up. So yes, there's definitely a lot of value for companies to actually go through this exercise, even if they do find it sometimes to be quite expensive. To go through all this effort up front.
Well, I mean, on the question of expense, and at the danger of blatantly advertising what it is that we all do, it might be a bit more expensive to draw up these contracts, because illustrations can take time and they can be costly. But if you've just saved one dispute, if you've eliminated one dispute with a functioning contract, you will have recouped that cost immensely. And what we've seen so far, I mean, we have this wonderful statistic, we call it dispute elimination. We now have dozens of these contracts out there in different fields and different industries. We have thousands of contract users of these comic book contracts, and we have yet to have a single dispute reported. Which is really, I mean, we're, as an academic, it's terrible, because I want to have some lovely court cases that interpret these contracts so we can start experimenting with court interpretation of images. But I got nothing, guys. I got nothing, because these contracts don't give us disputes, which is, victims of our own success in one regard, but also a wonderful thing in another regard, because they're working. So yes, they might be a bit more expensive to draw up in the first instance, but I have a postdoc right now who's doing a law and economics analysis of how much money they're actually saving, not just for the people who use them, but for society as a whole, with the disputes that they are eliminating. And it's quite interesting statistics she's coming up with. I'm not saying we're saving the world, but we're saving a lot of money.
Yeah, I mean, if you think of, I think you also need to look at cost in a certain context, right? So the moment you look at a pure, like a legal document that nobody's going to read, you want to spend, maybe you don't want to spend as much money on it. But if you start looking at it as an important part of your marketing docket, because now you speak better using that document to your audience, then I mean, don't you spend money in designing your marketing documents really well? So I guess it's also a different perspective that needs to be brought in here. But to the other thing that that Robert mentioned about how there's a pushback sometimes, that these contracts are open to interpretation. And that's where, the example that I gave about the solar rooftop company, where what we drafted was not the agreement itself. What we designed was not the agreement itself, but a summary to the agreement. So this was a 5-page, well-designed summary to a 100-page difficult to read contract. And what we experienced was that most people were happy just reading the 5-pager. By the end of the 5-pager, one, they had understood the key terms that they really needed to understand. Second, they had developed some comfort with what was on offer. And then they would just simply glance through the remaining 100 pages, or not even that, right? So it was easy to sell now. It was faster to sell now by virtue of that. Now, so again, I mean, different approaches for different use cases, but here it was important. We couldn't have introduced a completely illustrated document just because it was a very, very complex product we were talking about.
Just a question, Anirudh, because there's something that we've seen this before. We've seen excellent infographics explaining complex contracts. But the thing is, I would bet you that 99% of people will only glance at the contract, if at all, and they will only look at the infographics about the contract. So why do we need the 100-page contract if everything that is essential is in those infographics? If that's the only thing that people read, what purpose does that longer contract even serve? Why can't we just put it in a nice ball and burn it for firewood?
I'm with you for sure. But let's also understand that we are trying to change something which has been in existence for the last 500 years. You can't expect clients or even the lawyers, honestly, to warm up to something as radical for all use cases immediately. So for the
I can expect it. I can expect it and be constantly disappointed, but I'm still going to expect it, and I'm going to keep pushing that envelope because I think it is the right thing to do.
I'm also trying to push the envelope here.
I know.
More radically. Yeah.
Yeah, I agree 100%. I also agree 100% with you. I started off with this idea that there is, that it's fundamentally unfair to explain something to someone and then keep them legally bound to something that they cannot understand. So I also very much felt that everything that's binding should be in the easy to understand format. And because what we are doing is there's still leaving that, call it, to use your words, a trust deficit between what I'm understanding and what I have to legally commit myself to. But my experience also was that yes, we have to accept that this is a transitionary process that we're busy with. We're trying to change a way of doing that's been settled for hundreds of years, and therefore we have to appreciate that we have to sometimes do. And I've myself have now engaged in actually doing things which is more about explaining, for example, a policy, and where it's not the actual policy, simply because I see it as a necessary step in the path to bringing people on board towards what must be the end goal, is that everything that is binding must be easy to understand.
Oh, look, I appreciate that, and I don't mean to slight either of you. I have the luxury of sitting in a white ivory tower as an academic, where I can, spew the ideal. But I do realize in the real world, it's a real struggle to get people to embrace this. I'm just very lucky to be sitting where I am. But I used to dine out on the story you told me, Rob, about one of your clients who had two versions. I remember what they are, but I don't want to give anything away live on YouTube. But I remember what they are. They had a user-parent agreement that was in two formats. So you actually were forced to do both a comic and a text-based at the insistence of your client. But then, as I recall it, nobody ever used the text-based version. So
yes,
that's my client in itself.
Exactly. My client was really afraid that some of the parents would have a chip on their shoulder and feel that we are patronizing them by offering visual contracts, and then in the end, no one took the text agreements. Yeah.
No one. I think that just speaks louder than anything else.
I think Anirudh sir has to leave in about 3 minutes, so I just had one question coming in from the audience for him. How can we relate the concept to the Indian Contract Act or the perspective in the Indian scenario? Do you feel there must be some changes made in the act to bring in such type of contracts into force?
No,
not at all.
So here's the thing, right? The fundamental principle of contract is there needs to be a meeting of minds, right? We both need to agree to something, right? And if that agreement is not there, then it can't be a binding contract. So how do you intend to enforce a contract which the other party has not even read, let alone understand? Right. So I think what we're talking about actually aligns very beautifully with the requirements of the statute. Right. I mean, if Rob and Camilla have anything to add there.
Not actually, I was wondering if I could indulge you with just one more screen share, because I think the question was excellently answered by Robert French when he gave his closing address. So our former Chief Justice here in Australia was asked by us to give the closing address for the inaugural 2017 Comic Book Contract Conference, and he answered it beautifully. And I think, I may be wrong, but I think this is the first law review article entirely in comic book form. But let me know if I'm wrong. But we were very lucky to have some of our illustrators write us a law article. So I'm just taking you to the UWA Law Review website, where we have this article written entirely in comic book form about comic book contracting, amongst other things. And what they captured was the question at the end of the conference. So there you go, a nice law review, and then it changes to something a little bit unusual. So it's Stuart and Bruce, our collaborators and the leaders of the think tank for the illustration of my project, talking about the virtues of comic book contracts, and do some metacognition about how images can be effective in conveying things and the problems with avatars. And here we go. So Robert French, in deciding whether or not the comic book contracts were a good thing or not, he said, he, as a very clever man, he went straight to the bone of what it meant for the law and for the Indian Contract Act is, of course, a written version of the common law principles of contracting, which we also embrace here in Australia. But he said that as long as the pictures can be given meaning and be interpreted clearly, then of course any court should be able to deal with them. It doesn't require any legislative change because there are no form requirements on contracts. And what he does very cleverly is hone in on that one difficult aspect, and that is interpretation. But as Robert has already said earlier, interpretive issues with contracts have always been around. They're not going to go away. And what we simply have now is a different dimension on interpretation. And agreed, a bad illustrated contract will give you all manner of interpretive nightmares, but then so will a badly drafted contract with words. It does not require any legislative changes at all. This thing fits in a legal system that is screaming out for more clarity and transparency.
Thank you so much. We have the next question. How do you spread the word about such types of contracts?
Well, we did. It's such a good question.
Like this.
Yeah, like this. I never intended for this to be anything more than a favor for a friend. So I was making a UWA makers contract for a friend of mine in engineering, and then a mutual friend of Robert's and mine, she heard about this, and she linked me up with Robert. And then the media were talking to Robert. Then we did this ABC Law interview about 4.5 years ago. The next day, I had 859 emails in my inbox because it was a nationwide radio program, and the rest is history. I mean, one of the emails was from Oricon, who wanted to sponsor me to do this. We've been sharing things online. We've been doing conferencing. But the most powerful thing we can do is to make these contracts and get industry to share them. So because I'm an academic, I'm very lucky. I can force all of my sponsors to have a limited time period on the privacy of their agreements, and then I force them to make them public. And they're quite happy to do that. I mean, Oricon were very clever. They use this as a marketing technique as well. They won a lot of awards on the basis of their illustrated comic book contract, and they've actually changed the entire culture of their organization. Everything now in Oricon is illustrated. I think they have like 2 or 3 times more illustrators employed now, because everything, even their financial budget, has to be in comic book form. It's very interesting. They expect it now. And they advocate it by shouting its virtues from the rooftops. And so it's spreading to all different countries through use. I mean, we can sit here in these conferences and we can espouse the virtues of what we do, but I think the proof is in the pudding. The users, the industry users who are loving the uses of these contracts and who are seeing the dispute elimination, who are seeing the improved relationships, and who are seeing the benefits, they're the ones that are really, with word of mouth, starting a wildfire.
We have the next question. How would a person who has interest in contracts enter into this aspect of law? Is there a career path with regards to this?
That has to be one for Robert.
I think there is definitely a career path into this, and that path doesn't have to be through law. I think everyone can, a lot of people can add value. It's a very interdisciplinary effort to create a visual contract. You need people that are, that understand the business and do business analytics, have a business analytical approach. You need to you need illustrators, you need designers, you need lawyers, and so there's a variety of ways in which you can engage in this path, and it's not just limited to visual contracts. I think there's an entire legal technical movement as well that this is part of. So I think there's even because the point is not about creating a certain product. The point is to help users understand and consume contracts in an easier way, and using visuals is one way, but there are many other ways. And as Camella was sharing with us just before this conference started, she's now included contract innovation as part of her undergraduate studies. Sorry, Camella, I'm just kind of leveraging off that.
Not a secret.
And so I think there's going to be a lot of new ideas that are going to come that we're not aware of yet. So I think it's a nice blank canvas at the moment.
Well, legal design, I mean, from an academic or legal educator's point of view, legal design is becoming very interesting for universities everywhere, and it's something that there's becoming an increasing focus on. And I'm really gratified to see that, because for centuries, for millennia, lawyers have been more or less, frivolously ignoring the design aspect of the services they provide. We have made legal language by lawyers for lawyers without actually engaging with the people who use our services in a way that's meaningful. If you think about the medical profession, they actually have to learn how to talk to their patients. They have to learn how to describe their processes and how to interact with others outside the medical profession with what they do. We lawyers are not so good at that. But the whole legal design movement for me is about becoming more interdisciplinary, as Robert says, and about embracing other approaches and the value that other professions have in making your own better. And so I think I wouldn't describe it as a career path, but if you are a lawyer and you're interested in visual contracts, there is really only one thing you need, and that is an open mind. And you take that open mind with you, and then you open other people's minds with it. Show them what it can do. Show them what it is. Many people think that this sounds ridiculous and that, comic book contracts, they can't be serious. But when they actually see them and they see what they can do and they walk through an example, it begins to make a lot of sense. So all you really need is an open mind and a job with contracts, and you start suggesting little visuals here and there. Start with some icons, start with some little better layouts, and you begin to see the results. And then maybe one day you can move all the way to the extreme and push the envelope on the full-on comic contract. But as Robert says, there's more. I mean, we're also working on a virtual contract in a 3D, where you literally walk around a contracting environment and you make choices. We're working on video contracts. We're working on audio contracts. My mind is still being blown by some of the wonderful suggestions that my students are coming up with. These young students of law who in their third year unit are given the challenge of creating something unique. And they do. We had a set of students this year who made up a contract entirely composed of memes. It was hilarious, but more than that, it was effective. We had students who made an audio contract based on dialogues and little snippets with music, and absolutely the sky's the limit. Contracts don't have to have a specific form. Know your audience, know your industry, and create something that works. Just keep an open mind about how, and then your career path will be your own creativity.
I would like to take the last question for this very special evening. Why do you say that you need to consider convincing the client first rather than the lawyer? What are the suggested ways to convince them?
Well, I've never had to. As I said, the day after we did the ABC Law reports, I had a queue outside my door. Now, let me tell you something that never, ever happens to an academic, right? You never, ever have a line of people wanting to sponsor your research. That doesn't happen. You put in bunches and bunches of applications and you get ready to kiss frogs because you never get a yes, right? Once in a while, somebody might sponsor your research and you're very lucky. But comic book contracts brought industry to me. We had to audition banks to find the one that we wanted to work with. It was mind-blowing. We had to talk to and pick from people who are really keen to sponsor this research. That doesn't happen. This is something industry wants. I don't think industry needs convincing, but their lawyers sure do. Because the industry that are not the lawyers, they want relational, innovative, clear contracting. But I mean, Robert is in private industry, so he might have a slightly different perspective.
Yeah, so from a private, all I can share is my experience. I think that in my experience, it's much, there's in the legal profession, as lawyers, we normally respect the client-attorney relationship of our colleagues, and so we will not often speak directly to our colleagues' client. So in that sense, it's you sometimes have to approach it in a quite delicate way. But in my experience, the clients usually see the value of understanding and really are delighted by the effort that the possibilities of understanding something easily. No one enjoys reading long contracts. It's about as appetizing as eating cardboard. It's easier to understand the client, but you then have to bring the lawyer on board as well. And I think my experience is to try and involve the lawyer, try and get the lawyer to participate in the process. Respect that lawyer's concerns and position and his relationship with the client. You really have to, be quite mindful not to alienate that lawyer, because it's just too easy for another lawyer to be severely critical of what you're trying to achieve and dissuade his client from participating.
And I think that's very understandable. I think law as a profession is culturally risk averse. It's what we're trained to be. And simplifying a contract and making it different, of course, it's a risk. But I think the thing that convinces lawyers, and to some extent also industry, is that dispute elimination. That's a massive cost saving. I mean, both Robert and I have also experienced great feedback from sponsors and clients in the employment contracts, where the onboarding and the compliance training is so much easier and so much cheaper because the contracts are so clear. That's another great savings that the industry can really understand. That's conviction in and of itself. What was it they say? Money talks, but BS walks. It's very convincing. But also, I think the statistics that we're spreading, the engagement statistics, the comprehension statistics, and now also the perception data that we're generating through a new project. We're actually looking at how people who are in traumatic situations in finance, how their responses and how their psychological responses, we're working with neurology now, are better with visual contracts, and they make better decisions with visual contracts than they do with text-based. Really, there's so many different directions this research is going, all of it showing potential benefits of more innovative interactions between law and its end users. And it's just, a lot of it doesn't need convincing.
Thank you so much to the speakers for joining us today. I would like to call upon J. Kim Wright, ma'am, the founder of this very wonderful initiative, to make a few concluding remarks.
Thank you very much. This has been just delightful. It's definitely worth getting up early in my morning for. And I actually I like the idea of delightful contracts. And, I want to comment on your courage and doing something so innovative that you are changing the whole face of law. Like, contracts are so integral to everything that lawyers do. I mean, like, we have engagement contracts when we start a relationship. There are contracts everywhere, and if we change contracts, we're really changing the law. And it takes a lot of courage to step out of that 500-year history and do something new. And so I want to thank you for that. And Farhan, thank you again for putting together a wonderful program.
Thank you so much, ma'am. With this, we come to the end of the session. The audience have really loved the speakers throughout the course of the session. I would like to express my heartfelt gratitude to all the speakers for joining in today. It has been a pleasure to be associated with all of you. Thank you so much. With this, we come to the end.
Thank you very much.
Yes. Signing off is Mohammed Faransi. Thank you so much.